As an individual pursuing the master's degree in kinesiology to become a full-time football coach, the University Athletic Department is the perfect facility for this particular project. They're the ones that deal with all of the personnel, hiring and firing decisions, as well as policies and procedures to make sure everything runs smoothly and effectively. Under the area of risk management and application, the first case is Richardson versus Sugg. Richardson was the head men's basketball coach at the University of Arkansas Fayetteville. He felt that there was some discriminatory practices happening, and he did not report them to the university officials, but rather did so with the media. They went back and forth. Richardson persisted with the media, and ultimately Richardson was fired. Richardson claimed in the lawsuit that it was discriminatory practices, amongst other things, but he failed on all accounts to be able to prove that the university was liable. Ultimately, what it comes down to is that the university officials need to make sure that everything is in writing. Job descriptions, and in that job description for all employees includes, hey, if there's a problem, we need to bring it in-house first. Have three different individuals in multiple areas, so not all of them are within the football program or within the men's volleyball program, but three different individuals in the athletic department in different areas to report violations, harassment of employees, or any of those type of indiscretions or violations to superiors. Now, if that doesn't work and the university doesn't address it, then yeah, whistleblowers are protected. And if the media is going to be your first case, well, yeah, that's against our policy that we just outlined in your handbook that you signed before you ever earned your first paycheck. And even then, the media shouldn't be our first outlet. If we are a servant leader or serving under servant leaders, our job is to literally serve others and be a steward, to be a role model of how things should be. If we have a difference with an individual, we should address it with that individual. So part of being a servant leader and developing more servant leaders is modeling that behavior as well. Additionally, topics within the media need to be team focused, only on the team. The next area involves heat stroke prevention and the return to play process. In Class versus Towson did not allow one of its football players' class to come back after suffering a heat stroke. It was a long, arduous process that took many, many months, but ultimately the university doctors that consisted of an entire panel didn't view that class was ready to come back and play in a safe manner. The return to play process needs to have community practices involved. What's everybody else doing? The panel needs to make decisions, a panel of doctors. This inadvertently happened in this case, but was not a part of the university's policy, and it ended up helping them in the end win the case. The policy has to have the best interest, which is safety is our number one priority, of the athletes first. And then there has to be third-party involvement. Again, it can't just be one doctor from one individual. If there's any dispute, an outside agency, an outside doctor that will be paid regardless of how they find in the case will be paid and give their opinion. Additionally, if the final verdict of returning to play does not go in the student-athlete's favor in terms of what they would like, the university should allow that individual to be granted a runoff waiver where they're allowed to go participate in athletics at a different university. And if that pursuit is unfruitful, then they should be readmitted into the original college to be a student and honor the scholarship. And finally, under risk management and application, we have the case of Brzonkala versus Virginia Polytechnic Institute and State University. In the last area of risk management and application, we have the case of Brzonkala versus Virginia Polytechnic Institute and State University. A female was a victim of sexual assault by two male student athletes, brought charges, was drug out forever through two separate judicial review processes. Over the course of the second process, Coaches of the assailants became involved, but ultimately the review process said you're suspended, which is basically expulsion on the part of the assailant. He was found to have actually sexually assaulted through the judicial review process. However, a provost for the university decided, that punishment was too harsh. So it suspended all of the consequences, which would have allowed the assailant to continue to participate and graduate with less than a slap on the wrist. Title IX empowers universities to deal with these situations for all parties involved. And ultimately, and how Brzezina won this case against Virginia Tech was you have to be able to provide a safe environment for all individuals involved. Another way to help deal with this that the university here did not do is report all the alleged felonies to authorities. Anything felony, report to the local law enforcement. Have to have a university judicial process, which is a part of this, but we need to make sure that we have an independent panel of individuals rather than one individual that, I hate to say it, could be corrupted through outside sources to decide the eventual outcome. So if it's students that's on the initial judicial process, that's commonplace in many universities. The appeal process, if that involves other individuals, that still needs to be a panel of individuals rather than just one person making the ultimate decision. And also at no time, again, independent, no coaches can be associated with any official process in any way, shape, or form. In the area of employment laws and application, although not directly a university athletics situation, the University of Michigan Law School felt they had an educational obligation to do something about discrepancies in race and gender in their law school admission process. Grutter versus Bollinger highlighted specific ways to address these discrepancies that were lawful. A process first has to start by, do the discrepancies exist? If they do, then we can proceed to establish qualifications for the particular job or admission process that cannot have anything to do in any way, shape, or form with protected classes. It has to be about the job and the job only. There can't be any quotas involved in any way. We need to have X many females, X many males, or X many this ethnicity or that. No quotas. Then and only then can we address the equally qualified candidates. Now we need more females to address the discrepancy, or we need more this ethnicity to address the discrepancy. And finally, the part of this that's often overlooked is you need to evaluate the process to see if it was effective in actually addressing said discrepancy. And if no discrepancy exists any longer, the policy, oftentimes known as affirmative action, needs to cease. The next area is Lowry versus Texas A&M University System. Lowry was a women's volleyball coach. The men's coach moved up to a position that she wasn't even allowed to interview for or know about. Then the guy moved up to the athletic director. He gave Lowry some other title, and Lowry was a part of a different investigation involving a different case of Title IX violations. The athletic director didn't like that and ultimately stripped Lowry of her added-on position, but she retained the women's basketball coach position. After more digging, it was found that she wasn't paid the same, and she didn't have the same opportunities, so she sued. And she won. So what can we take away from this is, first and foremost, leaders have a duty to train from within in servant leadership. In other words, servant leaders need to train more servant leaders from within the members of the organization. And Galatians 3:28 says that, hey, we're all equal. So when we train, we're going to train everybody to the best of their ability. And when a job for promotion comes up, we're going to make sure that everybody knows about it. And all those that would like to it have an opportunity to apply and go through the hiring process. And if we have that equal opportunity, if you do have a job, any similar jobs are going to be paid equally. Additionally, athletic directors have an obligation to research what other community practices, what other universities are happening for their athletic trainers and basketball coaches and lacrosse coaches, etc., to make sure that they're receiving fair compensation. Finally, in the area of employment laws and application, we have the case of Jones versus the University of Iowa. Unfortunately, this also involves another sexual assault, and this was the gross mishandling of this by the dean of students and a in-house lawyer within the university. The dean totally mishandled every single aspect of his job in this case. He failed to protect the victim. He failed to talk to the assailants and totally mishandled everything about the case. At one point, he totally disavowed any knowledge of the case, even though he already talked to other individuals within the case. The in-house lawyer said, "Oh, the dean did everything right." A letter went to the regents that said, "No, this was totally mishandled." They hired an outside counsel to reinvestigate everything involved in the situation and found, oh my goodness, it was mishandled so poorly. So what can we take away from this? Job descriptions, including powers, abilities, responsibilities, everything that they could be doing needs to be handled and laid out clearly and communicated for all positions. When the dean of students, Jones, was fired and sued the university, he almost won a claim of due process because he wasn't granted a name-clearing hearing. So let's make sure that that's mandatory in our policies. And the independent investigation involving anything to do with a potential felony has to occur. So outside counsel. And we need to make sure that compensation of those independent investigators happens regardless of what the independent investigators find. That would help them if they become sued, the third-party investigators become sued, helps them in a qualified privilege defense. They're only after for the truth, which is ultimately what we're all after. Ultimately, Jones tried to cover everything up. We want to make sure that in those policies and procedures, it's clearly stated that if one attempts to cover something up, cover an impropriety up, that will result in a termination, no questions asked. And as previously mentioned, whistleblower policies should be in place here. An assistant athletic director in this case wanted to talk to Jones, the dean of students, but was brushed off and couldn't do anything else. So it was the one person that they could go to. Again, let's have 3 different individuals that they can go to so they can apply and proceed with any improprieties or violations in multiple avenues. Galatians tells us that we're all equal regardless of race or gender. In 1 Peter 2:17, we're supposed to love all humans. 1 Corinthians 10:33 tells us all leaders are servants, which reemphasizes the call for servant leadership. In Romans 15:1-2 tells us to all help one another and build each other up. And in 1 Timothy 3:1-7, in a nutshell, tells us, hey, leaders have to be above reproach. Be the role model in everything that we do. All of these simply factor in terms of how we treat one another and how we treat our employees. We are called to be servants of the Lord and of each other, to help build each other up, to help teach other individuals how to become leaders. And there's no discrimination against everybody because we're all equal in the eyes of God and should be in the eyes of each other. Additionally, the Bible is littered with parables, which I believe is an appropriate comparison to use in how to interpret law. In parables, it's not the nitty-gritty details of story that's important, but rather what is the moral and the teaching behind the parable that's important. When we view the intents of rules and laws, it's the intent and the spirit of the rule that needs to be addressed, which why I'm vehemently against the application of Test 1 for Title IX compliance. It should be eliminated. It doesn't do anything to help the intent of Title I of allowing equal access for the underrepresented gender. Leaders would do well to keep these teachings of Christ in mind as they are being leaders, but it's very difficult to do so out loud and praise Jesus in everything that we do if we work at a public university. And the reason for that is within the First Amendment and church and state separation. The First Amendment clearly states, according to Spangler et al., 2016, university officials that are public employees and state actors, state agents, can't promote or inhibit the choice of religion. Football teams are famous for having team dinners before football games. And oftentimes you will hear a prayer, regardless if it's public or private. Technically, those individuals could be found liable for violations of a student athlete's First Amendment rights. A potential way to not violate a student athlete's First Amendment rights, but still be able to allow for individuals to practice religion within the confines of a athletic event, if the student athlete so chooses, would be to simply say, here's a moment of silence. That way you're respecting the wishes of everyone, which is very, very, very tough for me personally, because I would much rather exclaim at the top of my lungs the wonderful teachings of the Lord. Unfortunately, or fortunately, depending on your perspective, I would be fired, and I would be absolutely okay with being fired if I was forced by law or by university policy to uphold a principle or standard of the university that goes against the core tenets of the Bible and the teachings of Jesus Christ, such as discrimination of any kind. If I was forced to implement a policy that required discrimination, I would absolutely be fired for not following the policy at all. Thank you much.